Welcome back, everybody, to the History of the Civil War, CHST 501. Last lecture, we looked at the institution of slavery as it was practiced in the British Empire prior to the 13 colonies going into revolt and breaking away from the British Empire to become the United States. In 1776, the colonists declared independence, insisting that, quote, all men were created equal and endowed by their creator with the inalienable rights of life, liberty, and the pursuit of happiness. This was not exactly to be the way it would be proclaimed in the Declaration of Independence. We'll see. The evolution of the United States essentially emerges out of a tax crisis. The British conquer New France, which included, of course, Toronto, where we're all residing, Quebec, what will become Ontario. In 1763, British North America looks something like that. In fact, the British had almost the entire eastern Atlantic portion of North America, the Atlantic Ocean side, the coast. The continent would have been shared a little bit with France, as you can see down towards New Orleans, and then with Spain. Now, the British insisted that American colonists pay for that 1763 conquest of French part of North America. And of course, colonists in the American colonies objected on the grounds that they were not represented in British Parliament, primarily. And the cry became, no taxation without representation. And so the colonies, 1776, declare independence and go to war now with the British Empire. And the Americans prevail. 1783, the Treaty of Paris will now give the new American states not only the territory that the colonies had held, but as well supervision over so-called Indian territory, where Native Americans have been slowly being pushed back. But all this now becomes recognized as territory under the 13 colonies. The United States doesn't exactly have a constitution at this moment, nor do they know how they are going to govern. They are indeed the United States in that plural sense, that they're sovereign states that are kind of cooperating in this territory, but they haven't got a system of government nor a constitution. Several states by now have banned slavery. For example, New York, Quaker, Pennsylvania, and there were reasons for that we again already explored in the previous lecture, mostly economic reasons. Slavery was seen, as I say, as being competitive with free labor, especially skilled labor. And we saw that some states had imposed tariffs on the import of slaves. Others began just prohibiting slavery, period, while other states prohibited the education and training of slaves in skilled trades. So every state would have its own system. At the moment, there is a government. It is bouncing around between New York and Philadelphia long before it's going to be situated in Washington, D.C., a territory that will kind of be a neutral territory that will be carved out. However, the federal government does have one thing in principle from the beginning is it has power over what are so-called unorganized territories. In other words, those territories that were not the original states, the Indian territories, as they'll be known. And so in 1790, in 1787, the northern states managed to succeed in getting the kind of provisional federal government now to pass this key piece of legislation that is going to apply to one particular territory. We see here how the United States was developing. The light blue here are the original kind of territories. You can see that in 1803, there will be the Louisiana Purchase that the Americans will make from the French, from Napoleon, as Napoleon needs to finance his wars in Europe. So a large portion of Western United States or Midwestern United States will be purchased at that time, with Spain still controlling all that orange territory. Indiana territory is where the problem is going to occur. And what we see slowly is by the time 1787 arrives, the states have essentially split into slave states and free states. The original 13 colonies now make up what is formerly the United States at that point in time. And going along the Mason-Dixon line right there that comes across Pennsylvania, you can see southern states will be slave states, and we often determine the South as lying along the Mason-Dixon line. So it's only one state away from Canada. In fact, we often get the sense that the South is, south of the United States is much deeper inland, deeper south, but in fact, it isn't that far away. It is, as I say, just south of Pennsylvania and New Jersey. So as you cross over into Delaware, Maryland, Virginia, and so forth, you're in the South. At issue, as I say, is this territory, Indiana territory, right there. Northern states prevail in the federal government to introduce the Northwest Ordinance of 1787. Congress now prohibits slavery in what is known as the Northwest Territory. Let's not confuse it with Northwest Territories that were, part of Canada as we knew them. As they say, it's also known as Indiana Territory, but it'll be called the Northwest Ordinance, roughly running along the Ohio River all the way over to Minnesota. This ordinance, imposed by Congress, will ban slavery in these territories should states emerge out of them. Now, the way the United States is going to function is when enough settlers settle in a particular territory, they can call a constitutional convention, they can adopt a constitution, and if that constitution is consistent with what is going to become the American Constitution, federal Constitution, then these states can petition Congress to admit them as a full state, And then at that point they become sovereign states with its own state, with a state legislature, state constitution, state criminal code, and so forth. And so what this Northwest Ordinance does is it immediately makes the formation of new states emerging out of that territory automatically free labor states where slavery is prohibited. Ohio, Indiana, Illinois, Michigan, Wisconsin, and Minnesota will, by law, have to be free states. They cannot adopt a constitution that permits the practice of slavery. And you can see the significance of this in terms of what it's going to mean to have congressional representation, especially on issues of slavery. The North is getting all these additional senatorial seats in the Senate as states begin to emerge out of this territory. And this is very bad timing in a sense because it happens before the Constitutional Convention. That same year, several months after the passage of the Northwest Ordinance, state representatives from the original 13 colonies now come together in Philadelphia for what becomes known as the Philadelphia Convention, Constitutional Convention, to hammer out the American Constitution and how it's going to work. Without a successful negotiation of a constitution that is acceptable to both southern slave states and northern free states, the risk is that the United States might not come into existence. It could just fall apart into individual states, or states may create mini countries. Nobody knows what the scenario is going to be. But obviously, southern states, in view of the Northwest Ordinance that had just been passed, are now feeling very vulnerable, feeling that they may be outrepresented by northern free states, and they arrive at the convention very insistent on a equitable constitution that will protect their rights as slave-holding states, and the rights, of course, of slaveholders, and this concept of slaves as property in the way a horse might be property, very much the way Justice Mansfield looked at that question when we looked at the Zong case in England. At this point, 10 states had already banned the slave state, and so, by then, 10 states had already banned the slave trade, and so this issue of slavery is now going to explode in everybody's face. The first question, of course, was how to divide power in the United States. And the question, of course, was there will be a higher house and a lower house. That's agreed upon. But the question was going to be, will Congress be represented numerically by population, rep by pop, representation by population? In other words, the way we do in Canada, the greater the population, the more senators and congressmen would sit in the House? Or does every state get a single vote? In other words, no state would outvote other states. And so we have a great compromise, as it's known. It's agreed that the lower house, the House of Representatives, would be based on state population. But the Senate, each state would have one vote. And the way it actually worked out is each state was going to get 2 votes because there would be 2 senators representing it. essentially they get equal representation, whether it's little Rhode Island or whether it's a massive state like New York. They still each only get 2 senators. The senators will sit for 6 years representing the entire state, 2 senators per state. They're considered to be wiser. They will be older, over the age of 40. Many senators are not elected directly at that time. In fact, they're appointed by state legislatures. But democracy, of course, has a different structure than we often think it is. Often, democracy was about property owners having the right to vote, the small selected population having the right to vote, and often congressmen and senators were just appointed by a legislature rather than being popular. The House, these are younger members, less experienced. They will be elected every 2 years from local districts, and the House will be represented by the number of population. Larger population, more representatives in the House of Representatives, the lower house. The southern states, particularly North and South Carolina and Georgia, now, when it comes to the lower House of Representatives, suddenly demand that they want to count slaves as part of their population for the purposes of congressional representation and as well tax appropriation. Whatever money the federal government raises, primarily through either tariffs or customs fees, there is no income tax at this moment, would be proportionally divided between the various states depending on the population. And now southern states want slaves to count for this. The problem is this, is at the time of this constitutional conference, slaves accounted for about 20% of the population of the United States, but 40% of the population in the southern states. And so if suddenly slaves were going to be counted, this would give southern states a disproportionate power in the House of Representatives. And of course, the House of Representatives is often from where legislation is advanced and then eventually reviewed by the Senate. So it's an important house. And of course, northern states immediately resist this. Northern states fear that they now are going to be outnumbered in the lower house. And so we get the first compromise that, as Americans like to say, the fathers of the Constitution, or the fathers, now adopt. This one, the first of 3 constitutional artifacts in this document that result from the existence of slavery. The first one is the so-called 3/5 compromise. It refers to Article 1, Section 2, Paragraph 3 of the United States Constitution, which reads, representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, in other words, those indentured servants that I had described, and excluding Indians not taxed, which would be indigenous peoples who are living on reservation territory, so they're not taxed. So including those bound to service for a term of years and excluding Indians, not tax 3/5 of all other persons. Notice that the word slave or slavery is not used. This particular paragraph essentially describes which people will be counted, and anyone who's left behind will be considered as 3/5 of a person. The word slave or slavery is not used. And so this 3/5 compromise augments representation for the South by approximately 30%, rather than the 40% they would have had if they considered every slave as a full person. Now, don't make the mistake that this means a slave has 3/5 of a vote. That's not the way. Slaves don't vote. And in fact, in many states, African Americans will be barred from voting, and people without property shall be as well. That is the kind of evolution of popular democracy as we're familiar with it will take some decades in the United States. However, what it does mean certainly is, for the purposes of how many congressmen will be sent to the lower house of representatives, slaves will count, the whole population of slaves will count as 3/5 of the number that there are, and that will determine the number of congressmen, and it will as well, of course, determine the number of the proportion of taxation that will then be forwarded by federal authorities to this particular, to every particular state. The second issue that comes on the agenda was what to do with the actual slave trade itself. 10 states had already banned it and wanted the ban incorporated into the Constitution. And again, we're talking about the international slave trade, the importation of slaves. That's, when they refer to the slave trade, that's what they're referring to, not necessarily the slave trade at home, the auctioning and selling of slaves across state lines or internally in the United States. We're talking about the importation of slaves from abroad, which Britain at this point in time is in the process of as well banning. Again, the southern states, particularly the Carolinas and Georgia, threaten not to ratify any constitution with a provision banning the slave trade. They insist that that matter is a question of state rights. Only they have the power, the individual states, to ban this trade. So again, a compromise is implemented. Article 1, Section 9, often referred to as the limits of Congress, reads partly, quote, "The migration of importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person." Again, slavery is not clearly defined here. The paragraph can be equally applied to immigrants, yet there are terms that apply to the notion of property, like duty, importation. There's a kind of a double-edged ambiguity to this paragraph in the Constitution. Congress will attempt to impose tax on slaves, and the moment they do that, southern states argue that taxing slaves would, one, constitute a public censure of the slave trade. Moreover, that such taxation, quote, degraded human beings by classifying them as merchandise. Very convenient argument for the slave states that are actually trading in slaves as merchandise. So again, neither of these two clauses actually use the word slavery or explicitly give slavery any kind of protection. In fact, Congress reserves the power to ban slave trade after 1808, and will proceed to do that. After 1808, not be able to import slaves into the United States, not legally, anyhow. The third item is going to be much more explicit, and it's going to end up binding the federal government into the slave trade, despite the fact that half of the United States will essentially be almost 50-50, will ban slavery. The question here is what happens if a slave held in a slave state, say like Virginia, escapes across the border into a free state like Pennsylvania. And so the southern states now insist that the Constitution have some kind of extradition clause that would recognize a runaway slave in a free state as a slave and require that that escaped slave be rendered or extradited back to his owner in the slave states. Article 4, Section 2, Paragraph 3, sometimes referred to as the Slave Extradition Clause, sometimes simply as the Extradition Clause. It reads as follows: no person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. And so again, the United States Constitution therefore neither authorized nor forbade slavery, nor did it authorize or forbid its abolition. It's exactly the same problem that, again, Justice Mansfield was facing, that there was no written law in Britain defining slavery. There was no precedent and common law for slavery in England. However, Englishmen were holding slaves, and thousands of them now. And once again, the Slave Extradition Clause does not use the term slave, nor is it in type called the Slave Extradition Clause. It refers to slaves as persons held to service or labor, and it defines slave owners as party to whom such service or labor may be due, almost as if it's a contractual agreement. And that notion of contractual agreements in slavery, you might remember, it's echoed when Queen Elizabeth I gives those instructions to Hawkins, the first British slave trader. We saw again in the Justinian codes that there were 3 states of slavery, by virtue of conquest, by virtue of birth, or by virtue of selling oneself into slavery. That's a form of contracting. So, again, 3/5 compromise describes kind of three persons and all other persons. No term involving the word slave. Limits of Congress, again, refers to slaves as migration or importation of such persons as any of the states now existing shall think proper to admit. And finally, the Extradition Clause refers to slaves as a person held to service or labor, and insists that they shall be delivered up on claim of, quote, the party to whom such service or labor may be due. Now, it's going to be a long history of debate now until the war breaks out some 80 years later as to what the fathers of the Constitution were thinking and what they were imagining. Most argue that the writers of the Constitution were viewing slavery bifocally, in the sense that the way it currently existed at the moment they were trying to form a country and adopt a mutually acceptable constitution, but also looking into the distant future where slavery would eventually be banned. And so the abolitionists will argue, as slaveholders argue that, the way gun holders argue that, this is sacred, it's enshrined in the Constitution, our rights to property, the way, again, Americans are arguing it's enshrined in the Constitution, our rights to bear arms. Let's not forget, by the way, that the Constitution is infinitely amendable. It's not the Bible. You can vote and change the Constitution. So that is always an option for Americans if they want to deal with the kind of gun issues. Just change the Constitution. In any regards, regarding the slaves. The argument is going to be made that when this Constitution was being drafted, it was the intention that slavery will be eventually banned in all of the United States, sooner or later. And the evidence we have for that, one of them is, for example, we can look at the earlier draft of the Slave Fugitive Clause. Originally, you could see it applies to no person held to service or labor. Right? The word originally it read. Let me go back to the actual. No person held to service of labor. Originally, the term was no person legally held to service or labor. That was in the draft. But when they actually presented to the word legally was dropped to ensure that the Constitution could not be interpreted as affirming the legality of slavery. And therefore, that's another reason that just the term slave does not appear in the U.S. Constitution. So it's a very document open to various interpretations, of course, to this day. And this is going to be now problematic. Slavery as well, while it is going to be vested in the state, every state will have a different slave code, the way every state has a different criminal code, property rights, marriage rights, family rights, and so on. Family law is under a state jurisdiction. Federal law only applies to a very limited number of areas in American life to this day. But slavery under the federal Constitution of 1787 while remaining a legal creature of state jurisdiction, nonetheless, there are kind of intrusions. Intrusions into the federal system. First of all, let's start off with just the capital of the United States, Washington, in the Federal District of Columbia. There it's decreed that the laws of Virginia and Maryland, both slave states, would now continue to be in force in the District of Columbia. Thus, the only incorporated federal district at that time recognized slavery. Secondly, the federal government has to deal with slavery on the international field. The government, for example, will seek compensation to owners of slaves carried off by the British during the Revolutionary War and the War of 1812. Compensation is sought for slaves from shipwrecked U.S. vessels in the British West Indies who are set free by the British in the 1830s. There's, of course, the famous case of the slave mutiny on the Spanish ship, the Amistad. Although, again, the Supreme Court of the United States will declare the slaves free, four presidents, Tyler, Pierce, Polk, and Buchanan, all attempt to pay Spain reparations for the loss of Spanish slaves, to underline and underscore the legitimacy of slave property. So the federal government, while some states are, as I say, abolitionist states and condemn slavery, the federal government must still represent slave states and their owners. So that's the second area. Finally, the third area is, of course, Western frontier territories or unincorporated territories. Again, this is the way I described, the Indiana territory where the Northwest Ordinance was passed. The federal government has power to regulate slavery in those territories, and the federal government has already made, by virtue of the passage of the Northwest Ordinance, made it clear that they will use their power in federal territories to ban slavery forever if they choose to do so. And so Indiana, Michigan, Illinois, Wisconsin, Iowa, all these states are going to be by law free states. Things are now going to go slightly tip the other way. In question here is North Carolina. And North Carolina, as you can see, is huge. And the western part of North Carolina decided that it wants to secede and form its own state. And North Carolinians had no objection to this. And so this, of course, is going to bring us the Southwest Ordinance. The question is the formation of what's going to be Tennessee from North Carolina. As soon as Tennessee began to petition for admission into the United States, there was, again, from the North, all sorts of grumbling and suggestions that Tennessee not be admitted unless it was admitted as a free state. And of course, by now, southern states have much better representation in the federal government, particularly again in the House. And so as part of the admission of Tennessee into the United States, the Southwest Ordinance is now passed. And the Southwest Ordinance essentially makes the admission of Tennessee on the condition that, quote, no regulations made or to be made by Congress shall tend to emancipate slaves in the territories. In other words, Congress cannot insist that a new state emerging out of, and in this particular case, it's not exactly a territory because North Carolina had already been incorporated into the United States as a full state, so and as a slave state. So it's a bit of a, it's not quite a clear precedent for unincorporated territory becoming a state. It already was incorporated. Nonetheless, essentially, the Southwest Ordinance now prohibits regulations to be made or made by Congress when admitting a state that will, tend to emancipate slaves in territories that are being admitted to the United States. And so this now sets a precedent for the southern region, and seven southern territories that practice slavery are going to be admitted into the Union by 1846. New states. We're talking about Tennessee, Louisiana, Mississippi, Alabama, Arkansas, and Florida. It appears to most that slavery is just collapsing under its own economic weight. Its industrialization has now globally kicked into an economic cycle, self-sustaining economic cycle. Slave-produced products, although important, are not as critical anymore. It doesn't appear at that point in time that slave labor is any more efficient or competitive than free labor, and there is a sense that slavery is going to collapse under its own weight. And it's a northerner that gives slavery a new breath of life. Eli Whitney, 1794, patents the cotton gin, or the cotton engine. And this will suddenly make slavery viable in a way it never had been before. This is a machine that strips the lint off cotton, which actually makes the usable part of cotton. And it used to take a slave 10 hours to produce a single pound of cotton by hand. But using this hand-cranked engine or cotton gin, a slave now can produce 1,000 pounds in 10 hours. In other words, 10 times the output. And this suddenly makes slave labor very economical indeed for picking cotton and for cleaning cotton. And suddenly slavery now begins to boom, and plantation owners, particularly at this moment in time, cotton plantation owners begin to invest in slaves. They take out mortgages, they get loans. Everybody is investing in slaves in order to put them to work with cotton gins in hand into the cotton industry. In 1808, as promised, Congress bans the international slave trade, but it does not ban slavery at home. And although a few slaves are still being smuggled into the United States, mostly from the West Indies, some maybe from Africa, but from this point on, from 1808 onwards, the majority of slaves in the United States will be natural-born Americans, second generation, third generation slaves. And moreover, the survival rate of slaves in the U.S., particularly in Virginia, is much higher than that in the West Indies. And so there is this kind of natural growth in the slave population. While northern states ban slavery in their territories, the southern states now begin expanding their agricultural base on a growing slave labor pool. And for now, the issue of slavery just quietly limps along without any problems for about roughly the first 35 years of 40 years of American independence until 1818. In 1818, the United States is equally balanced between 11 free states and 11 slave states. But in 1818, in the territory of Missouri, a part of the 1803 Louisiana Purchase from the French, there are about 10,000 slaves living in this Missouri territory. And in 1818, the settlers of Missouri get together and they petition Congress to admit Missouri as a slave state. And of course, the former Louisiana Purchase territory is not part of Indiana territory. So the Northwest Ordinance does not apply to Missouri. Before there's a panic in the North that suddenly, we're going to be outnumbered by one if we admit a new state and it becomes a slave state, a part of Massachusetts, just the same as a part of North Carolina seceded, a part of Massachusetts now secedes to become Maine. And the assumption, of course, is and the correct assumption, that Maine, as a far northern state, is going to be a free state. And Maine now asks for formal admission into the United States the way Tennessee did once it seceded from North Carolina. And so everything would be fine. You have one new slave state and you have one new free state. And it would be 12 versus 12. As long as Missouri was admitted as a slave state and Maine as a free state. And of course, now the politicians are going to get into the picture and complicate things. New York, Representative James Talmadge, he is going to propose an amendment to the bill admitting Missouri that as a condition of its admission into the United States, it adopt a program of gradually phasing out slavery by admitting no more slaves to the state and emancipating children of current slaves when they reach the age of 25, reflecting kind of this concept of gradual emancipation. This becomes known as the Talmadge Amendment 1819. The how from southern states was deafening, and suddenly, for the first time, Congress finds itself debating just not the practicality necessary or economics of slavery, but its very morality. Nobody was prepared in 1818 for this debate or its vehement. The amendment, the Talmadge Amendment, was broken into two parts so that they could be considered separately, and surprisingly, both portions of the Talmadge Amendment passed in the House. But once the bill gets to the Senate, where the chamber is equally divided, slave and free, um, here Southern senators now begin to argue that Congress has no power to exclude slavery from Missouri. Rufus King, Northern senator from New York and a signer of the Constitution, argues that the U.S. Constitution did not prevent Congress from restricting the growth of slavery. William Pinckney of slave territory, slave state Maryland, also a signer of the U.S. Constitution, effectively argued the opposite, that new states needed to be admitted as equals of the original states, and that no special provision should be added to the terms of their admission. Concern for the plight of slaves now swept through the North. It surprised almost every politician in Washington. State houses, state legislatures throughout the South now pass resolutions backing the addition of Missouri as a slave state. Northern states, of course, condemn the admission of Missouri as a slave state, and Congress is stalled, and so they move the bill to the next sitting of Congress. The House still supports the Talmadge Amendment. The Senate has enough votes to kill any admittance bill passed with any kind of anti-slavery amendment. And Maine now can't get into the United States unless all this is resolved. And so for the next sitting of the House for 1820, Senator Jesse Thompson of Illinois is going to propose what will become known as the Missouri Compromise. A line south of 36 degrees 30 minutes is going to be drawn across the territory of the former Louisiana Purchase territory, Missouri territory, right there. That's the line. This will become known as the Compromise Line. Any state, any territory in the Louisiana Purchase that asks admission into the United States north of that line will be required to adopt a free constitution, with the exception of Missouri. And so Missouri is admitted into the Union as a slave state, but no further state in the Louisiana Purchase can be admitted further. And if you look at this map, certainly can't be admitted further as a slave state. It has to be a free state. And so if you look at the map, you can see the problem that's beginning to emerge for southern states. Arkansas territory below the Missouri Compromise line, it, of course, can maybe two states they can squeeze out of that territory that could become slave states, but otherwise there's nowhere else for the United States to move. Once you leave Arkansas territory, you're in Spanish territory, and later you're going to be in Mexico as the Spanish leave. So this, of course, does not bode well for the future. The other part of the compromise, of the Missouri Compromise, was Henry Clay adds an exclusionary clause. Missouri has to amend its state constitution, recognizing that free blacks are citizens and not slaves. It's called exclusion clause because it excludes free African Americans from being treated as slaves. And of course, despite of the term compromise, many Southerners do not support this measure. As I say, out of the territory of Arkansas, very little remains for slavery, very little territory for slavery to expand into this. And a lot of American politicians and political thinkers are very suspicious of this Missouri Compromise line, what it entails and what it means. Thomas Jefferson, the third president of the United States, the champion of what's referred to as Jeffersonian democracy in the United States, he'll see ill winds in the Missouri Compromise. Jefferson says, quote, "This momentous question, like a fire bell in the night, awakened and filled me with terror. I considered it at once as the knell of the Union. It is hushed, indeed, for the moment, but this is a reprieve only, not a final sentence. A geographical line coinciding with a marked principle, moral and political, once conceived and held up to the angry passions of men, never be obliterated, and every new irritation will mark it deeper and deeper," end of quote. And so Thomas Jefferson, back in 1820, essentially is anticipating the physical now demarcation of where slavery can go and not go as something that is going to drive Americans towards eventually war, civil war, and of course this is a good 45 years, 40 years before the Civil War is going to break out. The result of this kind of first national debate on slavery, and it's not so much the debate on the morality of slavery as much as it is on the question of new territories adopting slavery as they enter the United States and bringing it into the United States, and taking a position as a kind of a pro-slave state. There is a sense now of a division between what are free labor states and slave states, and everybody wants to have the majority, or at least control a kind of a 50-50 balance. Nobody wants to be outdone. Maine, by the way, is then admitted as well. So they do maintain the balance. But what this does is makes a lot of Americans really aware of slavery, kind of in the way the Zong case did in Britain. And so by the 1830s, you now have a militant abolitionist movement. William Lloyd Garrison kind of becomes the lead figure, Lewis Tappan as well, Theodore Weld. They form the ASS, the Anti-Slavery Society. On the eve of the Civil War, some 200,000 Americans in the North will belong to the Anti-Slavery Society. And William Lloyd Garrison as well founded the abolitionist paper, the Liberator. This was a newspaper that was dedicated to one subject, the emancipation of slaves. At first, the Liberator advocated for the emancipation of slaves and their repatriation back to Africa. But gradually, William Lloyd Garrison will repudiate so-called gradual emancipation, kind of the kind that Lord Simcoe had imposed in Ontario. Once gradual emancipation meant that once a child born into slavery reaches the age of 25, they will be emancipated and therefore will produce no more slave children, whether they're female or male. Problems are, however, beginning to emerge in the question of the extradition of slaves. One of the problems with that extradition clause that I read to you from the Constitution, when applied to runaway slaves, the US Constitution, they never provided any kind of enforcement mechanism. Who's going to render the slaves? If a slave escapes from Virginia to, say, Pennsylvania, who is going to render that slave back? There is no clearly defined constitutional enforcement mechanism. The assumption was that the state judiciaries would cooperate with each other. That if a slave arrives in Pennsylvania, Pennsylvanian courts will ensure, and the state attorney general, that the slave is arrested and then the slave is rendered or extradited back to their owner in the slave state. However, free states now, especially regarding these tensions between in Congress between slave states and free states, plus on top of that now a moral and philosophical objection to slavery, free states refuse to cooperate with slave states. And so this is going to start very slowly sucking in the federal government to mediate between free states and slave states on the issue of the extradition of slaves, and if not mediate, then just take it over. Now, there is actually a Fugitive Slave Law of 1793. This Fugitive Slave Law, federal law, first of all, it sets aside normal legal processes, such as, for example, the writ of habeas corpus. We saw how that was used in the courts of England to push forward abolitionism. It does not give an escaped slave the right to a trial by jury. A slave accused of being an African American accused of being a fugitive slave, let's give them a presumption of innocence, had no protection against self-incrimination, no assurance that he or she can testify in their own defense. And so normal rights granted for Americans charged with other crimes are not available to an escaped slave under the Fugitive Slave Law, 1793. It also makes it a federal crime to assist an escaping slave. And what this Fugitive Slave Law did is it established this kind of quasi-legal mechanism by which escaped slaves can be seized in free states. They have to be brought before a local magistrate, and the magistrate then has to give an order for the slave to be rendered back to their master, to whatever state they came from. The Fugitive Slave Law or Slave Act, liable to recapture at any time, anywhere within the territory of the United States, along with any children subsequently born of enslaved mothers, even if these children are born in a free state. Furthermore, there is no penalty in the Fugitive Slave Act for a pursuer to take a captive back home without going before a magistrate and getting that warrant of extradition. And this becomes, of course, an open invitation to kidnapping, and an entire slave bounty hunting industry now grows up, sometimes seizing Americans, declaring them an escaped slave, and dragging them off into slave states and reselling them there as slaves. As a result, free states now begin to pass a number of, quote, personal liberty anti-kidnapping laws, primarily to protect free African Americans from being seized by slave dealers and slave hunters, by bounty hunters as well. In addition to this, many state-appointed magistrates, when bounty hunters bring them before them, tend to just dismiss the bounty hunters' petitions. And so that further encourages kidnapping. And that brings us to the 1842 case in the U.S. Supreme Court, Prigg versus Pennsylvania. In 1826, the state of Pennsylvania passes a law, a personal liberty law, which states, and it's only one sentence, I'll read you that sentence, quote, if any person or persons shall, from and after the passing of this act, by force and violence, take and carry away, or cause to be taken or carried away, and shall, by fraud or false pretense, seduce, or cause to be seduced, or shall attempt so to take, carry away, or seduce any Negro or mulatto biracial, from any part or parts of this Commonwealth to any other place or places whatsoever out of this Commonwealth with a design and intention of selling and disposing of, or of causing to be sold, or of keeping and detaining, or of causing to be kept and detained such Negro or mulatto as a slave or servant for life, or for any term whatsoever, every such person or persons, his or their aiders or abettors, shall, on conviction thereof, in any court of this Commonwealth having competent jurisdiction, be deemed guilty of a felony. There it is. One sentence says it all. And so, as I say, this personal liberty law is passed by the state of Pennsylvania, March 25th, 1826. 6 years later, 1832, an African-American woman, Margaret Morgan, escapes from slavery in Maryland to Pennsylvania. 5 years later, 1837, Edward Prigg led an assault and abduction of Margaret Morgan in York County, Pennsylvania. They took her to Maryland, intending to sell her as a slave. The 4 men involved in this abduction were charged and arraigned under this Pennsylvania 1826 law. Prigg pleaded not guilty and argued that he had been duly appointed by Margaret Morgan's owner to arrest and return her to her owner in Maryland. However, a Court of Quarter Sessions of York County, Pennsylvania, on May 22nd, 1839, convicts Prigg in finding him guilty of a felony under the personal liberty laws of the state of Pennsylvania. Prigg now appeals to the U.S. Supreme Court. And the role of the U.S. Supreme Court, I'll discuss it in a little bit more detail later, but of course the U.S. Supreme Court is the final court of justice in the U.S. It has final say mostly over the question of whether a law is constitutional or not. There were all sorts of formulas what happens if a state passes a law but it contravenes a federal law, or it doesn't meet with the provisions of the American Constitution. Who's going to solve that? Well, the U.S. Supreme Court will. It's going to be agreed. They have the duty of judicial review, and primarily, as I say, they're reviewing the Constitution, whether a law is constitutional or not. They don't really have much authority to make any other kinds of decisions other than the constitutionality of a particular verdict in a court. And of course, the Supreme Court, once it got a hold of this case, immediately reverses the Pennsylvania verdict. And it's an important case because it tests the Fugitive Clause. The Pennsylvania law, according to the Supreme Court, violates Article 4, Section 2, Paragraph 3, the Extradition Clause. Therefore, personal liberties laws are unconstitutional if they contravene the Extradition Clause. The court also added to this a ruling that the Federal Slave Fugitive Act of 1793 has supremacy over the Pennsylvania personal liberty law as per Article 6, Paragraph 2 of the United States Constitution, known as the Supremacy Clause. And the Supremacy Clause reads as follows: this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So, in some ways, the Supreme Court is certainly ruling against personal liberty protection for African Americans in free states. However, at the same time, the Supreme Court leaves a back door open to free states in its decision, in this decision, Prigg versus Pennsylvania. It also adds, however, that local magistrates may choose not to exercise their authority to order a slave extradited, quote, unless prohibited by state legislation. So, in one hand, it prevents states from protecting free African Americans from being abducted. On the other hand, it doesn't force free state magistrates and the free state judiciary to enforce an extradition of a slave if it's prohibited by state legislation. So once again, we have a problem. You know, it's neither here nor there. And this, of course, if you don't have a kind of a clear ruling or a clear decision, is you know, the road to war as well, if the courts can't take the responsibility for what they need to do. The doctrine of judicial review essentially argues that the United States Supreme Court is not to make law, it only reviews the constitutionality of the law and of court decisions. Whether, for example, a piece of legislation has is compatible with the United States Supreme Court, and secondly, whether a decision made in a lower court, say in the state court or even county court, municipal court, whether it is also the decision is constitutional, or the law under which an individual was charged, whether that law was constitutional. But that's essentially the doctrine of judicial review. The Supreme Court is not supposed to make laws, and tends not to this day. And so the reaction to this, of course, leads to free states to pass new personal freedom laws, which prohibit state officials from interfering with runaway slaves in any capacities. Runaways could not be caught or incarcerated. Cases could not be heard in free state courts, and no assistance could be offered to those wishing to recapture slaves. But if they just go in there and take the slave, that, personal liberty laws cannot be applied either. The other thing that the Supreme Court as well introduces is a historical necessity thesis. This ruling acknowledges that the institution of slavery might be abhorrent, might be even incompatible with the Declaration of Independence, the very core political foundations of the United States. However, the Supreme Court stated that the Fugitive Slave Clause of the Constitution unquestionably, quote, constituted a fundamental article without which the Union could not have been formed. And so this is, again, the pathway to war, because essentially you have a judiciary, the most supreme judiciary of the land, declaring an institution as being incompatible with the institutions of democracy and the principles that this republic has adopted, yet at the same time tolerating it because of historical necessity. And that kind of, again, judicial behavior is once more a pathway to war, because if you can't get justice in the court, how else are you going to resolve this kind of injustice? Supremacy Clause, of course, is at issue in the United States right now. It's potentially going to explode in somebody's face in some state where cannabis is legal. This is just waiting to get in front of the Supreme Court. As you know, some states, like California, for example, have legalized cannabis. Washington State, for example, which borders with British Columbia, has legalized cannabis. The federal government has not. And so even Washington State and British Columbia, both free cannabis territories bordering with each other, it's a federal crime to carry cannabis across the border in any direction. And it's a crime under federal law in states where cannabis is legal. And it's just a matter right now of discretion on the part of the Department of Justice. There's obviously some kind of pressure on the Department of Justice to wait. Let's see, maybe this is actually a great source of tax revenue, or maybe conservatives in the U.S. government are waiting for the appointment of a conservative judge to the Supreme Court, which looks like it's about to happen. And one point or another, at some point, somebody in California or Washington who is legally growing and selling, distributing cannabis is suddenly going to get a heavy charge, life imprisonment kind of charge under federal law, and we're facing a huge constitutional crisis as so many states have now chosen to essentially override the federal law, but they don't have the power to do that. The Supremacy Clause says that if a state law and a federal law conflict, federal law has supremacy. And so I cannot imagine, if the laws stand as they do currently, a federal judge or a Supreme Court judge ruling in any way other than for conviction. And that would just immediately shut down the entire cannabis industry in all of the United States. And so this is what might be waiting the next constitutional crisis in the United States, because of course cannabis has become such a major business and is sold in so many states now. The other thing you got to remember as well, in terms of the historical necessity thesis, is this is some kind of special category of higher law within the Constitution, permitting the existence of an institution as contradictory to the spirit and intent of the Constitution as slavery. It's not even law. It's a law beyond law. The historical necessity thesis. I can't think of any other case where it has been argued, but certainly Prigg versus Pennsylvania, that decision, that historical necessity thesis was raised. The final thing I have to say about the U.S. Supreme Court is that it's a customary court. It's not. Its functions are not defined in the Constitution. Its functions are customary. It evolves out of custom, not the U.S. Constitution. The U.S. Constitution provides for the Supreme Court, but does not define its function and powers. And there are no provisions that the Supreme Court has to be obeyed. The obedience to a Supreme Court decision is entirely customary. And so we have presidents who have ignored Supreme Court decisions. In fact, we're going to see that Abraham Lincoln will not only ignore an order of a Supreme Court justice, but will turn around and almost arrest the justice, the Chief Justice of the U.S. Supreme Court, Justice Taney. And it's only Lincoln's advisors who managed to talk Lincoln out of arresting him, and Lincoln just ignored those decisions. I think there were decisions as well on Guantanamo Bay, the prison there, the anti-terrorist facility, the terrorist detention center, that George Bush just simply ignored. So a president, if he thinks he can take the heat in the next election, can choose to ignore the Supreme Court decision. It's of course at his political peril, but there's nothing can happen if you ignore the Supreme Court. Or we could look at it the other way. Anything can happen if you ignore the Supreme Court. It could be a total door to complete societal collapse.